Hello, everybody. Welcome to UA Spotlight. We are here again with author and lawyer Adam Freedman. He is the author of two books. The first is The Naked Constitution, What the Founders Said and Why It Still Matters. He also is the author of A Less Perfect Union, The Case for States' Rights. Both excellent books. If you haven't really read anything yet on the Constitution, I would suggest The Naked Constitution first, and then definitely get a Less Perfect Union. They really go together quite well. I've learned a ton myself from the books. I've also recommended them to a bunch of friends who said they were well written, easy to read, not getting into too much legalese. It's a great overview, and it will give you a base to get into more complicated constitutional stuff. And speaking of complicated constitutional stuff, we're going to talk about the 14th Amendment. But first, I just want to, the 14th Amendment has been construed to mean many different things. People, it's a long amendment. And I think people think it's just, what the purpose was. And you could correct me if I'm wrong. The purpose was to make sure that the freedmen were treated, as or equally under the law as citizens of the United States, because prior to that they were not necessarily citizens of the United States, and that that the 14th Amendment would give the freed slaves full citizenship and equality under the law, hence the Equal Protection Clause. Is that really the purpose of the 14th Amendment generally?
I think that's the motivation for it, but of course the 14th Amendment does not mention race or slave status. The motivation, I think, was exactly as you say, but the instrument for doing that, the amendment, the crucial parts of the amendment take certain federal guarantees that were in the federal Constitution, and guarantees those to individuals against their state governments, and then adds equal protection, which was not a federal provision, but adds that to state level protection. And then it's got some other stuff in there about disqualification of office holders who had previously been involved in an insurrection against the US. So tries to also, it's a little bit of a, like a purge as well of the ex-Confederate government from the southern states.
So just to start off, I want to start with the Citizenship Clause. That was in the news recently when Donald Trump said that he wanted to end birthright citizenship. And a lot of people on the left and the right had said that this violates the Constitution, that if you're born in the United States on American soil, that automatically you become an American citizen. Is that necessarily the case? Is there a right, to become an American citizen solely because you were born on American soil?
Well, that's certainly the way the courts and successive administrations have interpreted it. And although I'm no fan of Donald Trump, he may be onto something there, because there are certainly plenty of experts who question that. I think if you look, Will, at the text of the 14th Amendment, it doesn't just say all persons born in the United States become citizens. It's all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And the writers of the Constitution and of the constitutional amendments are very economical with their words. The Constitution, even when you include the amendments, it's a very short document. And so typically these things are hashed out very carefully, and we know from the historical record that the 13th, 14th, and 15th, the post-Civil War amendments, were very actively debated. And so this phrase, subject to the jurisdiction thereof, has to mean something. So there are two parts of the citizenship test in the 14th Amendment: born or naturalized in the United States, one. Number two, and subject to the jurisdiction thereof. There isn't a lot of evidence. There isn't a lot of evidence about what they meant, but this was meant to. We think that this was meant to exclude people who may have been born in the United States, but may have owed a loyalty to some other place. So the children of diplomats, for example. There was some question about American Indian, Native American tribes who actually are still not technically under the record covered under birthright citizenship, because they were carved out before this birthright doctrine evolved. American Indians were carved out in a separate law to grant them citizenship. And so it's a little bit weird, the state we get into now, where on the historical record, Native Americans get their citizenship through one way, but the children of an illegal immigrant
Right.
get birthright citizenship through the 14th Amendment.
Just to clarify for Native Americans, that a lot of them didn't want to be American citizens, that if they were born here, they didn't necessarily want to be under the jurisdiction of the United States of America, that they were considered to a degree these tribal sovereign nations to a degree, that where Congress could only regulate commerce within, and it gave them a certain purview, but really that they didn't want to be American citizens. So it wasn't anything that was kind of like, oh, we don't want them to be American citizens type of deal, which it's framed an awful lot as.
Right. No. I think it's like the children of diplomats. It's whether you owe a loyalty to a different sovereign, and the Indian nations are, have sovereignty. They are considered separate sovereigns, and so how can you say when a baby owes allegiance to some other sovereign? Well, you have to look at the parents, right? And so I think there's a legitimate question about whether somebody who has not, a family that has not gone through the legal process to become citizens here, whether they completely owe allegiance to the United States as a sovereign. So to me, birthright citizenship is at best a questionable doctrine.
And a lot of people will cite Juan Kimark and say, well, that gives the government, that means that through jurisprudence that people of illegal aliens that are born here do become American citizens. But Juan Kimark was a judgment on legal immigrants having children here, right? So if Juan Kimark says that legal immigrants here that have kids, their children are automatically American citizens, where did birthright citizenship come from? Was it kind of just burped up out of the bureaucracy that at one point it was just all of a sudden became law? How do these things happen without anyone's input? The American body politic has zero input in it. It just seems that some bureaucrat one day said, well, they were born here, they're citizens, and that they do it under the radar, under our noses.
Yeah. It's a good question. Historically, well, I'm not sure exactly when that
right. I can't pinpoint that either. Like at what point
became dominant.
Right. I mean, it's shocking that we have a rule of law and it's not really, and that someone that's not even, now we're looking at somebody who's not even a judge seems to have changed it, that it wasn't even adjudicated on.
Yeah, and a very, very important and significant rule of law. I don't think anyone ever voted on it.
It's amazing and scary. So now we get into how judges kind of change law, and I want to start with the much talked about, much misunderstood due process clause. Can you give us a little background on the purpose of the due process clause? I mean, the one confusing thing is that we have a procedural amendment that has been given substance, and I think a lot of people are confused on that point. What is the difference between due process as a tribunal and substance that the court has given it?
Right. So it's a great question. The due process clause began in America. The due process clause began in the federal Constitution as part of the Bill of Rights in the Fifth Amendment, with words that are repeated in the 14th Amendment, more or less verbatim, about how the government cannot deprive the citizen of life, liberty, or property without due process of law. In its original incarnation in the Federal Bill of Rights, in the Fifth Amendment, as applied to the federal government, was clearly part of the original founders' desire to rein in the federal government and prevent tyranny. The due process of law was a doctrine that always referred, as far as I know, and my understanding from legal historians, is always referred to judicial process. Alexander Hamilton said in the Federalist Papers that due process of law not in the Federalist paper, but later when talking about the Fifth Amendment when it came up, said that due process of law will never refer to a legislative act, but only to a judicial act. And so when when those words of the Due Process Clause got transferred to the 14th Amendment, there was no discussion at the time that the concept of due process was being broadened from essentially a guarantee of procedural fairness in the courts to a broader idea of legislative fairness. And yet that is what happened. It happened initially during the Progressive Era, when courts used it to rein in some of the quote-unquote progressive legislation at the states, to say that the legislation was unfairly inhibiting liberty of contract. And then more recently in the Warren Court and later eras, it has been used to overturn a variety of state laws that judges find to be not sufficiently progressive or just distasteful from a policy perspective.
So just to clarify for the viewers, what you're saying is that due process has always been a procedure, just a judicial process. And now that you have judges overturning legislative acts by saying it's violating the due process clause, that we don't like this act of the state legislature because we deem that it's a violation of your rights and a violation of the due process clause, whereas it was never meant to overturn legislative acts. Correct? That this due process clause can't infringe on necessarily what the legislature is doing, and that if you use substantive due process, you're kind of just writing in the predilections of a judge again to overturn a certain legislative act within the states.
I think that that's right, and I think that to me is the most fair reading of the due process clause. That, you know, given its historical background, both in 1789 and in 1868, the fear was, at one point, a federal government that would lock people up or send them to the gallows without due process of law. And in the post-Civil War era, it was the same thing about the freedmen, the idea that former slaves would be locked up, disenfranchised, or even hanged without due process of law. Now, there is an argument that due process is procedural, but it also refers to a legislative process. And so that courts should be able to see whether the legislature really considered the merits of an issue or whether they were unfairly influenced by special interests or by invidious motivations to adopt a certain law. And that is a type of procedural argument. It's true. It goes to legislative process, but I'm not persuaded of that yet.
Right. And there's a couple of things. I want the viewers to know, where did substantive due process come from? I mean, we're talking about original intent. We're talking about original meaning as a means of jurisprudence, how to interpret the law. And if the framers didn't intend for there to be a substantive due process clause, it was around the Civil War when Robert Tawney, who was a Southern sympathizer, first used substantive due process. Can you give us a little background on why he would want to give the due process clause substance at that time? That this was in the Dred Scott case.
Yes. Yeah.
Right.
Well, yeah. I think the record on that is a little mixed. Here's what we know is that when referring to the Missouri Compromise, or the I believe it was the Missouri Compromise that he was referring to.
Yeah.
Which decided for a while, what states would be slave and which territories and states would be slave and which would be free. He said such a law, in one sentence, said such a law cannot be dignified by the term due process. He doesn't really lay out a doctrine of substantive due process, but he plants a seed that somehow the term due process is one that can be used to dignify a good piece of legislation. The doctrine as such doesn't really take off until some years after the Civil War, I would argue anyway. And that is in the era after after what's known as the slaughterhouse cases, which was in which the Supreme Court considered the privileges or immunities clause of the 14th Amendment and essentially sort of sucked the life out of them. There was this original provision in the 14th Amendment which and maybe we'll talk about it some more, but offered the hope of a very robust set of rights guarantees, substantive rights guarantees for the citizens of the states. The Supreme Court rendered that more or less meaningless, and so future courts kind of casting around for some provision with which to strike down state legislation that they thought was unwise or wrong-headed for some reason, landed on the due process clause. And it's really in those years, in the last quarter of the 19th century, I think, when substantive due process really starts to take off.
So just to clarify, what you're saying is that the Privileges and Immunities Clause, which we'll discuss, the privileges and immunities meant rights and liberties that were expressly outlined in the Constitution, in the Bill of Rights, life, liberty, property, and that they mentioned in the 14th Amendment before directly before the Due Process Clause. This kind of incorporated the Bill of Rights to the states. And what you're saying is that they rendered that meaningless at one point, the Supreme Court, and then when they were looking around for something like that, they found it in the Due Process Clause, and then incorporated the Bill of Rights through the Due Process Clause rather than through the Privileges and Immunities Clause.
That's correct, Will. And
okay.
there's a clear historical record that the ratifiers, the drafters, and the ratifiers of the 14th Amendment, when they talked about privileges and immunities in that context, meant the kinds of rights guaranteed by the first 8 amendments to the Constitution, the 9th and 10th Amendments being more sort of meta amendments. And so the right to self-defense, the right to bear arms, explicitly mentioned, and also some of the rights which we might call genuinely fundamental, like the right to earn a living, arguably were covered also by the Privileges and Immunities Clause. If we had stuck with privileges and immunities, we'd have an historical record that may be able to confine the meaning of privileges or immunities. Instead, we've shifted to due process, which has no real, it's divorced from any historical record. So judges put whatever they want into that.
Right. So it gives them kind of a blank slate, right? To just throw their personal kind of like what we saw with the marriage decision, that under substantive due process, since we're on the topic, they created the fundamental rights doctrine, which basically says that that the due process clause, protects these fundamental rights, and we don't know what those rights are. So it seems that the government can kind of dream up whatever right it wants if it doesn't like certain legislation. Or if it does like certain legislation, it can just say, well, you have a right to this or you don't have a right to that. And that we kind of have a court or 9 justices that are largely telling us what our rights are. And it seems that people are okay with that, or it's being underreported to a degree, that every time that the Supreme Court gets a case, it's kind of like another constitutional convention. We never know what we're going to get.
Right. Well, that's right. And it makes it hard for people on the originalist side of the constitutional debate sometimes to argue about this, because the court always casts itself, and it's reported in the mainstream media as being magnanimous. It's giving rights, right? The Obergefell decision, love wins, and those people who don't like Obergefell don't like love, and they don't like rights.
Right.
But they're forgetting the most fundamental right that our system is based on, which is the right of self-government. It's the right of the people of the United States to govern themselves rather than by the King of England. But then within the United States, the right of the people of each state as a community to sort these complicated social issues out for themselves. Because for every right that you give to, for every right that's fundamental, like same-sex marriage, there are downstream effects where you take away rights. For example, the rights of religious believers to abstain from celebrating same-sex marriages, or the right, for example, of Catholic charities to decide to place children only with opposite-sex couples rather than same-sex couples. And those are some real serious issues that are better left to the local level.
I totally agree, and you're right about self-government, and that brings me to another point where Randy Barnett's book, and we talked about it off air a little bit. who is an excellent constitutional scholar, wrote a great book, Our Republican Constitution. In there, he makes the argument against a democratic constitution and a Republican constitution, not the parties, but democratic meaning democratic by majorities, and Republican by you have rights that exist, and the government's duty is to protect those rights and against majorities in most cases. And his argument would be that we do need a court that adjudicates based on individual liberties, that we should have a court that will overturn state law that are violating individual rights, and that you should fear at all times majority rule, and that legislatures aren't always right. Would you agree with him wholesale on that? Through a lot of that judges should really hold a lot of that power? I agree with him to a certain degree. It's not that they shouldn't at all, and we do have a Republican constitution where rights are protected. But I think there's certain other mechanisms as opposed to the judiciary adjudicating on a lot of these things that are built in to protect those rights as well.
Right. Well, I think Professor Barnett's book is a very important book, and I agree with his central thesis that our Constitution is a Republican Constitution, and that our rights come first, that rights precede government, and government exists to secure the rights of the individuals, which is what the Declaration of Independence says. As far as the role of the judiciary in policing the legislature, I don't agree completely with his argument at the federal level, right? I think he makes a strong argument for courts as a judicial duty to do more than a superficial analysis of law. Was it passed by 50+% of the legislators? Okay, it's fine. No, there's a serious argument that courts should take a real look at laws and try to find out when a law that is superficially meant to protect health and safety, for example, is really there to entrench special interests. But I'm not yet convinced why that isn't the job of the state judiciary.
Right.
The state judiciary can be conflicted, it's true, but so can the federal judiciary. State judges can be corrupt, so can federal judges.
And the states have constitutions too, right? I mean,
that's right.
The states have charters that protect these rights, and if these rights are being violated, the next, there's another state to go to. I mean, I don't know why we always look to judges for liberty.
That's right. I think that is true. You can vote with your feet, and I think that's the most important point of federalism. The legislators can be thrown out of office, but again, the classic case that Barnett is talking about is where it's clearly a minority,
right,
whose rights are being infringed, and so the elections won't necessarily help. But if a state doesn't have an independent judiciary, then that, I think, is a federal problem. Because the federal Constitution, interestingly enough, I don't know why Randy Barnett doesn't make more of this in his book, but the federal Constitution, in the original body of the Constitution, guarantees to each state a Republican form of government. And so, and presumably, Professor Barnett thinks that's Republican in his sense of Republican, and I agree. And so I think that if a legislature passes improper legislation and a state judiciary consistently fails to enforce the state constitution to protect the rights of the minority, maybe then you have a federal case. Maybe then you can appeal to the federal government for violation of the Republican Guarantee Clause. But in the first instance, it should be the states.
And couldn't you also, not just the Republican Guarantee Clause, like we talked about earlier, if they hadn't screwed up their Privileges and Immunities Clause, that they can also adjudicate on that too, if it was a violation of liberty, right?
That's right. Where a state legislature violates anything that is clearly protected by privileges and immunities, then you have a solid ground for a federal case.
Okay, and correct me if I'm wrong here. I'm reticent to allow the federal government to even do that, to apply. You know what I mean? Just because of the way it's been so abused, that I would prefer these other checks and balances, meaning federalism, to really encapsulate that, as opposed to the federal judiciary, that if they are violating rights, if it's a minority or majority at the state level, other states have the incentive to, I don't know, bring people to their state to not have these same laws, and that people will vote with their feet, again, move. And if if you have this large exodus from a state, the state legislature is going to say, God, we're losing power here by the minute. We got to change this law, or this law isn't correct. And that, people moving with their feet is perhaps the best option,
Yeah.
and and the people as the actual sovereign, the people that are sovereign over the Constitution, and the Constitution that's sovereign over government, or political actors, that we, the people, need to pay better attention to what's going on. And I think that over time we've really relied on the courts, that, I don't have to pay attention to this, the courts will do it. And people just, whatever the courts say is kind of, that's the final word. And people have really accepted that. And that it's really become, I think it's really eroded the fabric of the civil society to a degree. I mean, I could be going too far here, but from my observations, that's really what I've seen with this overbearing kind of interventionist judiciary.
Yeah. Well, I think those are good points. And I think that's why a lot of conservatives are reluctant to revive the Privileges or Immunities Clause of the 14th Amendment, because it will open up a new vista for judicial activism. And I share that concern, but I think that we can't pick and choose when it comes to constitutional provisions, because to me, it's a very bad precedent to say this clause of the 14th Amendment, it may not work in practice, and so I'm going to ignore it. Because you can say that about a lot. Free speech is a really problematic part of the First Amendment. It leads to all kinds of crazy things and debates that I'd rather not get into. But it's there, and I can't jettison it. So,
and just to clarify, for originalists, or people that are originalists or conservatives, I think Justice Clarence Thomas, who really doesn't hold back, certainly in his opinions, or wanting to kind of erode that excrescence of jurisprudence, would agree with you that the Privileges and Immunities Clause should be the thing that incorporates the Bill of Rights, and not due process law. That I can't remember what case it was, but he said, I think it was Heller.
Yeah, it was McDonald.
Yeah, McDonald, and he said that the Privileges and Immunities would be a better vehicle for this type of adjudication.
And in an op-ed before the McDonald decision came down, I believe that Professor Barnett himself had said that this would be a good opportunity for the court to revive privileges or immunities. And so I don't read Professor Barnett as being hostile to that clause either.
Yeah, no, I did, and in our Republican Constitution, neither did I. It seemed that he supported that very idea, which is all interesting stuff. And I mean, I think people should really know, what's going on with the 14th Amendment, and what are the meanings of these clauses, and what is the jurisprudence specifically of the Equal Protection Clause. Again, in Obergefell, a lot of people thought that was an Equal Protection Clause case. Can you explain, what the Equal Protection Clause, what the original intent of the Equal Protection Clause was, and what the meaning has been, and a little bit of what the jurisprudence has been since, if that makes sense?
Yeah, it was originally understood fairly narrowly as a guarantee that it's sort of the flip side of due process, right? So you get due process of laws, but that only works if the same law applies to people similarly situated. And the idea was you can't create a different. I mean, it was on criminal laws, right? So you can't create a criminal law that applies, say, differently to people of color, and then convict them and say, well, I followed due process because we took them to court, we had a jury, and there was no due process violation. But there just happened to be a different law that applied to Black people. Well, the Equal Protection Clause levels that playing field. So not only do you have to go through all the procedural steps, it has to be the same type of law that applies to whites, Blacks, and all. It was very rarely used for the first, I think almost the first 100 years. It was not used. It was not invoked by individuals very much. It was invoked by corporations who who are by railroad corporations that argued that against having different rates of taxation from other corporations. It was kind of a corporate clause in the beginning, but it then became kind of a substantive, like a substantive equal protection clause, because really all laws are about dividing up different types of people, right? I mean, almost every law makes a categorization of some type of person or another. People under 16 years old can't drive,
Right.
so that's not equal. People under 18 can't vote, so that's not equal.
Mm-hmm.
And the law, and goes on and on. So really it became a way for courts to say, we don't like the kind of classification you're making. And so rather than a guarantee that people similarly situated would be treated in a similar way, it allows courts to go one step further and say, we disagree with your definition of who is similarly situated.
Right, and I think you brought up a good point. I think some of the laws that were overturned by the Equal Protection Clause, and I'm not sure, was states had different drinking age laws for men and women. For men it was 21, for women it was 18. Obviously, younger guys were, they're more prone to risky behavior, and that alcohol contributed to that, and they were deemed a greater public risk than women. And I think that was overturned on the Equal Protection Clause case, which I don't think. And then this is how you can look at the original meaning and say, look, it was never intended to overturn laws like that. That it was intended to make sure that everybody, that irrespective of your skin pigmentation, that it really created what Clarence Thomas would call a colorblind constitution. Not necessarily that you can't discriminate on certain attributes, right, of people. Would I be wrong?
Yeah, I think that's a good way. I think that's a good way to put it. Those kinds of distinctions, whether we agree with them or not, drinking age and even those archaic rules about who can drink and who can't. Even if you disagree with them, I don't think that that's what equal protection was meant to get at.
Mm-hmm. Okay. Well, that's pretty interesting stuff. I mean, I think that you have a lot of this stuff kind of in your book, The Naked Constitution. You talk about you talk about marriage in here and some other 14th Amendment stuff and jurisprudence. And then you get into the 9th and 10th Amendment in here, which are really important too in a less perfect union. And you have great research skills, good scholarship in these books. They're really well done. Again, I want to thank you for coming on and talking about the 14th Amendment, a largely complicated issue, and clearing it up for the listeners and the viewers. I hope it helps. And I really do suggest buying the book for beginners, The Naked Constitution and a Less Perfect Union. I don't know if you wrote them for them to be read together, but that really seems like that's the case, Well,
it's the same publisher, so you can read them independently, but if you want to read them together, I'm delighted. They do complement each other.
And Barnett's book was really good, and you have a lot of similar arguments, but explain them a little bit. For a layperson, it's a lot easier to understand in your two books for people that are beginning. And that a book like Barnett or some of these other, or Bork, I would think you should read after. That this would give you that foundation that you would need, and you relate it to people's everyday lives, especially about the administrative state. It's perhaps. Barnett writes about the administrative state, but I think you do a better job relating to people on the dangers and how the administrative state is in fact working right now. And maybe that was the point of your book, was to really kind of attack that fourth branch of government that's kind of insulated from the body politic.
Well, that's a big part of it, Will. And look, it's really a pleasure to be on, and I'm honored to be mentioned in the same breath as Professor Barnett, who is one of my constitutional heroes. So thanks very much.
Yeah, no, thank you. And we'll have you on again sometime to talk more about, I'm sure there's going to be something controversial happening in the near future, and I'd love to have you back. So thanks again for coming on.
Sounds great. Thanks, Will.
Buy the books. There they are. They're nice looking books too. Everybody, thank you for watching and have a good day.